not being heard.
Who is
the
that?
party is not being heard.
Who is when you're using the word I? Who is the I here?
Litigant. The litigant. Because
एक second, sir. Tahammul. The litigant. That leads me to another question. Your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner, and I'm saying this thing that we brought this petition
in
the interest.
You got the answer. Now please proceed. I've got the answer.
In the interest that the law should take its course. The constitution must be upheld. And I am also saying that I'm sure with such preliminary sitting there, the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please.
We are not going to platitudes. I will not make a political speech.
Khwaja Sahab,
I'll refrain from that.
Just proceed with that.
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and 2 senior judges, you have an objection to that. That's your proposition.
I think your Lordship has possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of
let us clarify.
Is it your argument that Section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's not fine. 2 and 3 have to be read independently and separate.
Now, please.
There are 2 in exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position, so many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions, and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
In fact, to be very honest, I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers.
In fact, powers will be whittled down. As if this law goes through, the powers will be whittled down, but we will explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is of course 2000.
ऐसा फिर आप आंसर करने बैठ गए।
I will continue. Let me
आप नोट
continue.
कर लें, बाद में कर लें।
Let me continue.
Mr. Khwaja, I will add it.
Then is a question.
Mr. Khwaja,
Yes, sir.
right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been.
I think
That's the moot question.
the answer to that is that it's noted, sir. It's noted, and I will only say this thing that Supreme Court. What is Supreme Court? Supreme Court is Chief Justice and so many other judges.
Faiz, we'll be sitting here till 12 o'clock.
I know that, sir. Let's
So,
let's go. I will only say this thing that this certainly is the Parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition. I've not even heard, and 3 judges or 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point. Therefore, to that extent, Section 3 is present. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court.
Do you object? First say, I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7, why not 6?
Please.
I object to this thing that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, Section 4? Say something. We should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges.
Noted.
Because this is very strange, because all judges equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5, then there's a question of appeal, and which is a very relevant point.
Khwaja Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not. I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the Parliament. About how the benches are to be. I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your suggestion.
No, sir. I'm saying this thing that under the 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the Parliament.
Okay, now let's proceed. We'll ask.
I'll argue on that. That is
the
the point which needs consideration. 5 is appeal. Yes, Marisa.
On Section 4.
On 4.
If memory serves me right, Section 4, what is the equivalent of Section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is, that when the framers of the present constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches. The question is this, that model, that aspect was not accepted by the framers of the present constitution because they had a model both from India and from Pakistan itself. So the question is this, if that was not accepted, does this not require constitutional amendments? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूँ आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
मैं बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुनिए ये सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं सर, ऐसे नहीं है।
आपने यही कहा आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए कि जब सुप्रीम कोर्ट एक
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं,
ठीक है, अदरवाइज तो आप आपकी मुश्किल
मैं आई एम क्वाइट आई एम वेरी
नहीं आगे बढ़ते हैं।
I have worked with all of you, sir, and
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
मुझे कोई problem नहीं है. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases.